8 sitting U.S. senators, and someone had taken their phone records. Senator John Kennedy turned to Attorney General Pam Bondi and asked a question, but it didn't sound like a question. If I called AT&T and asked for a senator's phone records, would they give them to me? Bondi laughed. No, Senator. Kennedy continued, step by step, slowly. And with every step, Bondi confirmed one more thing: possible cause, judicial approval, right to appeal, legal liability, notification obligation. Each confirmation was laying the groundwork for the next question, and that groundwork led Kennedy exactly where he wanted to go. There was no raised voice in this hearing. The document was not slammed on the table. There was no personal attack. Kennedy set a silent trap. He made Bondi affirm her own legal standards, step by step. And then she used those standards to ask what happened to the phone records of 8 senators. Bondi's response was, I can't discuss this matter. But the issue wasn't the content of that answer. The issue was that the questions themselves were now on record. Kennedy started by setting up a scenario. As a citizen, he calls AT&T. He is requesting the phone records of a sitting U.S. senator. Will they give them to me? Bondi, no, Senator. Kennedy continued. Will they ask me for a summons, right? Bondi, yes. And they will probably ask which planet I fell from, right? Bondi chuckled softly. Probably, Senator. Well, what should I show on that subpoena? Did I mention we're talking about a sitting U.S. senator? And with that question, Kennedy's true purpose began to emerge. Bondi replied, you need to show probable cause. Kennedy paused. He left 2 words hanging in the air. Possible reason. Yes, probable cause. These 2 words define a very specific threshold in American law. Concrete and reasonable grounds to believe that a crime has been committed or is being committed. Abstract suspicion is not enough. Intuition is not enough. Guessing is not enough. And here's the kicker. John Kennedy didn't debate or redefine the threshold. He just got Pam Bondi to sign off on it, because this issue was already settled law and Bondi had to concede it. And then Kennedy kept questioning after he got her approval. Kennedy distinguished between 2 different types of summons: standard subpoena and duces tecum, a subpoena requiring the production of documents. Was the threshold different for the second? Bondi explained, you need to show good cause, and you have to show a belief that a crime has been committed, or may have been committed, or may lead to other crimes. Kennedy confirmed, about a sitting senator. Bondi confirmed. And then Kennedy took one more step. Did a judge have to sign this subpoena? Bondi, yes. John Kennedy recorded this and continued. But the notable point here was that Kennedy was not yet directly cornering Pam Bondi. He was just setting the frame. He was getting Bondi to approve the legal standards that needed to be applied, in his own words, from his own mouth. And Bondi approved each of these standards, because he had to approve them. These were indisputable legal facts. Kennedy brought the issue to the phone companies. What would a legal advisor for a company like AT&T do if they saw this subpoena on their desk? Bondi answered carefully. If a company believes a crime may have been committed, it cannot alert the person involved. Notification is prohibited. Kennedy laughed. You've never seen me commit a crime, have you, General? Bondi laughed. No, Senator. The room relaxed, but Kennedy didn't stay there. But the main critical point was this. Kennedy asked about the right to appeal. Could the phone company contest this subpoena? Bondi, hypothetically, yes. It can be challenged with a reason. John Kennedy narrowed the question by asking, would a reasonable legal advisor have objected? And if the company hadn't, would there be liability? Frame. Pam Bondi said that phone companies generally comply with a U.S. prosecutor's subpoena. But Kennedy pointed out that this is not mandatory. It can be contested. And if it wasn't contested, there should be a legally justifiable reason for it. Tightening the discussion around a stricter accountability axis. Kennedy brought the question into the internal notification chain. And this transition revealed the true focal point of the trial.
In large institutions, at the FBI, at the Department of Justice, certain decisions are not made alone, especially politically sensitive decisions. Requesting the phone records of a sitting senator is one of the most sensitive of such decisions. Kennedy set up a scenario. If Kennedy were his special advisor, and Bondi is the Attorney General, and if Kennedy is trying to obtain the phone records of a sitting senator, would you expect me to tell you this? Bondi's response came instantly. You had to say it. Kennedy, yes. And these two letters, yes, changed the course of the trial. Because this question was no longer theoretical. The phone records of 8 senators had been obtained. And Kennedy was now asking, in this process, was this notification obligation fulfilled? Was former FBI Director Wray informed? Was former Attorney General Garland informed? Both questions hung in the air in the courtroom. Bondi replied, I can't discuss that. But the questions themselves were now on the record, and a question that is recorded continues to exist, even if it remains unanswered. Kennedy reached a concrete question. About this matter with the 8 senators, did anyone tell former Attorney General Garland? Bondi replied, I just learned about this very recently. Director Patel, too. I can't discuss the details. I don't know most of the details. Kennedy's response was brief. We need to bring Garland here. This sentence was not said loudly. It didn't come with a dramatic gesture, but it landed with a certain weight in the courtroom. Because Kennedy was implying one thing. If these events occurred during Garland's tenure, the person who should be held accountable is not in this room. And if there is no accountability in this room, then we need another hearing. He then rephrased the question for FBI Director Wray. If the special counsel is trying to obtain the senator's records, does he inform the FBI director? Bondi replied, generally, the FBI executes subpoenas. Kennedy paused. This was not an answer to the question. Kennedy had asked whether the director had been informed. Bondi had said what the FBI was doing. They were not the same thing. At this point, John Kennedy chose to drop the issue because he saw that he didn't need to go further. The gap that had formed was already clearly recorded in the minutes, and he assessed that the area revealed by Pam Bondi's responses was noted. John Kennedy calmly said, I have 12 minutes left. I'm going to move on to another topic, effectively closing the discussion. This was not a retreat, but the completion of the framework he had set up. Because he had designed his questions not for Pam Bondi to reject, but to confirm certain legal assumptions. And Bondi had moved forward by agreeing with every point in that framework. The probable cause threshold was confirmed. Judicial signature requirement was approved. The right to appeal has been approved. Legal liability was approved. Notification obligation was approved. And then, the fact that the phone records of 8 senators were obtained was placed alongside these standards. Were these standards met? Kennedy did not ask the question to get an answer in the courtroom. He asked that question so it would be recorded in the minutes. And this was what changed the course of the trial. It wasn't a single question. It was the meeting of an approved framework with a single unanswered question.
We said that in this hearing, voices were not raised, documents were not slammed on the table, and there were no personal attacks. But that doesn't mean there was no pressure. Kennedy applied pressure through a different means. He had Bondi approve the legal standards, and then he used those standards as the framework for questions about what happened to the phone records of 8 senators. This is a classic technique used by a prosecutor in witness questioning. First, get them to accept the rules. Then ask where those rules lead. Because the person who accepts the rules must also accept that those rules are not being applied, or reject them, and that rejection itself becomes meaningful. Bondi noticed this technique, and he responded to every concrete question with, I can't discuss that. This answer could be technically defended. Sharing details about an active investigation with the public during a Senate hearing could be institutionally problematic. The structure established by John Kennedy was more about producing records than generating answers, because the answers given did not eliminate the existence of the questions, but rather documented which points remained open. In this context, elements such as the approved legal standards, unanswered questions, and the request to inform Merrick Garland were recorded. Therefore, while a Senate hearing does not establish the truth, it serves as a mechanism that documents what was asked, what was accepted, and what was left unanswered. These questions remain in the record. They don't have answers. Kennedy didn't shout. He didn't throw a document. He didn't resort to personal attacks. He used the law. He used Bondi's own words, and he used each affirmation to set the stage for the next question. 8 senators, phone records, possible cause, judicial approval, notification obligation. It's all in the minutes now. The message coming out of this trial is, the sharpest pressure doesn't always come from the loudest voice.